Hey, so today we will start with our evidence July 2024. I will just go through a question. If any question you want to ask, you can type in the chat box. So Harun comments a civil suit for defamation against Song Chi due to the streaks of derogatory statement attributed to Song Chi Twitter account, now identified as X. This statement labeled uh, Forum as corrupt, dishonest, hypocrite, sneak, and lala. The ownership of the Twitter account by Songchi was not in dispute. However, Songchi contested authorship of these derogatory tweets, asserting that they were posted during the period when Songchi was away on the accusations on to Mount Everest. Quorum claims was dismissed by the Sections Court, which held that he had not sufficiently demonstrated Songchi authorship of the tweets. And the Section Court decision rested on the grounds that Quorum fails to discharge the burden of proof on the balance of probability that Songchi was responsible for publicizing the derogatory tweets. Quorum had enlisted your service to represent him in appearing against the Section Court decisions. So explain how would you argue the point on appeal by reference to the Evidence Act and relevant case law on the burden and standard of proof of the party concerned. Okay, so basically the facts is like this. K, as a plaintiff, want to sue for defamation, but then Sections Court dismissed the action on the grounds that he failed to discharge the burden of proof. Okay, so generally, the burden is on the plaintiff, we all know, right? 101, 102. But then now we are talking about making a statement in online. So in this case, then we need to refer to section A, section 114, capital A. So in section 114, capital A, it basically is a presumption. It reverses the burden to the person who made comment on online. That person has the duty to discharge. The account is not belongs to him. Okay. This one. So I just briefly explain what is section 114A. So basically the title is Resumption of Facts in Publication. So there is three subsections. So basically sub 1 says, if we can prove the account belongs to you, then the court may presume you are the person who sent this message. Number 2, if we find out the Wi-Fi, using your Wi-Fi to post this thing, then we also presume you are the person. Then number 3, if we find out the device is your laptop or your computer or your phone, then the law will presume you are the one who sent this message on Facebook or Twitter or whatever. So, like we say, generally 101 and 103 put the burden on the plaintiff. But 114A actually is called reverse burden. They put the burden on the defendant to discharge, to say it's not you, it's not your account. So on the facts, Song Ji never dispute the ownership. So which means he admitted it's him already. So when he admitted it's him already, 114A will put the burden on him to show he was away and is not sent by him. Which means the presumption is rebuttable. Just because the law presumes you are the owner, right? It doesn't mean you cannot rebut it. You cannot tell the court this is not you. Although it's my computer, but maybe my sister use it. Although it's my Wi-Fi, but if somebody come to my house, use my Wi-Fi. Okay. So on this point, they are asking you, if you are appealing, on what point you will go and appeal? So for these questions, you should use 114A to say the session court judge actually make the wrong decisions on the grounds that the burden to fail to discharge is not on K, is on Song Ji. Because Song Ji, as a defendant, he also admitted it's his account. The burden is on him to prove he was away, and the account is not posted by him. Okay, so this question should be 114A. Okay, if you guys need some explanation, please let me know. I will proceed to second one. Okay, Section 32 sub 1B and Section 73 capital A of the Evidence Act 1950 serve as a statutory exception to the general inadmissibility of hearsay evidence. However, it is essential to note the differences between these sections. Okay, First of all, I think everybody understand what is exception to hearsay, right? So briefly explain is that in evidence we prefer best evidence, which is for example, uh, I heard something, I see something, I should be the one to go to court and explain. This is best evidence, okay? Or it's a document, then the original document should bring to the court. It's the best evidence. But when the first sources did not come to court, but we ask the second sources. Let's say I see, but then I tell my sister go to court and explain. She is basically giving a hearsay evidence. So what is the difference between this 32 sub 1B and 73A? 32 sub 1B, if you look at the title, he is a ordinary course of business. It's one of the exception under section 32 lah. Because 32 there are a few exceptions. So the D2 sub 1B, in order to use the D2 sub 1B, it must be made in the ordinary course of business. So for example, I am selling books, let's say. So if I'm selling my book, I will issue invoice, I will prepare a delivery order. All these documents, let's say I misplaced my original document, or the person who prepared this document is not available to go to court, then the next person is allowed to go to court. Okay. But for section 32 sub 1B, another requirement is that that statement must be prepared by the maker. So for example, I'm the person who prepared the invoice, but let's say I resign already. Sorry, I'm the maker, I prepared the invoice. Uh, that statement must be prepared by a person, Renault, who has knowledge, then only can use this exception to be admitted in the court. But if let's say Renault has the knowledge about the business, but Renault asks somebody to do, that somebody has no knowledge about these transactions, then this is not, you cannot use section 32 sub 1B to admit this evidence because they only admit the first-hand evidence, which is the person who has knowledge to prepare this document can then and only can use 32 sub 1B. Okay, but on the other hand, if you want to use section 73A, okay, documentary evidence in civil case, number one is 73A only applies to civil case. Number two, the maker has personal knowledge. Okay. However, if the maker had no personal knowledge, the information must be supplied to him by the person who had knowledge. So we use the same example. Renault has the knowledge about the transaction. Renault asked the clerk to prepare it. So although the clerk does not have the knowledge, but Renault supplied to him the information supplied to him by a person, Renault, who have personal knowledge. So as long as I have the personal knowledge, I tell somebody to prepare, even though that person don't have personal knowledge, is fine. This evidence still admissible under section 73A. Okay, number two, the documents in question form part of the continuous record. So if let's say the documents I ask my clerk to prepare, is every time we need to prepare one, it's a continuous record. Let's say record who owe us money, record we deliver order to who's, all these will form part of the continuous record. And number three, such statement was made in the performance of duty to record. So in short, 32 sub 1B, you can only admit the first-hand evidence. But 73A, it can be a second-hand, third-hand evidence, as long as the first person has a knowledge and it's a continuous record and also the performance of duty to record. I think the logic is like this. If we are just doing our daily job, we just record only, cannot be I go and record a wrong info, right? So that's why this kind of evidence will be more reliable. Imagine if every document also you would think is lie, then everybody must come to court already. So if today we done at the 73A, Renault have the knowledge, have to go to court. Renault clerk who record it also have to go to court just to say, yes, I recorded it. So Renault just to say, yes, I know these transactions. So that's why 73A actually is like helping us. We don't need to call so many party to go to court. Okay, so this is the main difference between 32 sub 1B and 73A. But of course, for 15, you need to write some introductions, like explain what is hearsay, why we got the exception to hearsay, and then you explain what is the requirement to 32 sub 1B and also 73A. Then you make the comparison. Actually, I think there are a few comparisons. Yeah, let me show you. Okay, so this is the one. So I can cut it and then I share to the group, so you guys can use it as your answer lah. Okay. So, okay, we can just quickly go through as well lah. So number one, 32 sub 1B is only for ordinary course of business. Like I say, it's only for business. But 73A never had this restriction to say only for business, as long as it's civil case. And 32 sub 1B does not mention only civil, so it can be civil and criminal. But for 73A, it expressly say it's only applied to civil. And then for 32 sub 1B, it can be written, it can be oral, as long as it's the ordinary course of business. But 73A is only for document. Okay. And then 32 sub 1B is only for first hand, like I explained just now. But 73A can be first hand, second hand. Okay. And then for you to use section 32 sub 1B, the maker must be unavailable. But for the 73A, the different requirement is that maker of the statement was called to give evidence. The maker was not available, but the provision of sub 1, which is the one is this one. Okay, if the maker is dead, unfit, or unreasonable to secure, or the court dispense with the attendance of the maker. Okay, but it's kind of similar lah, this one. But it's just that the court got discretion to decide whether I want the maker to come or not under 73A. And the last one is that 65, 66 can apply to section 32 sub 1B. 65 and 66 is the documentary evidence, which is the primary and secondary, the original photostat, that one. Okay, but on the other hand, 65 and 66 do not apply to 73A. 73A sub 1 require original to be produced. Okay, so this is the difference between 32 sub 1B and also 73A lah. Okay, then let us go to our question 2. Okay, Wendy consulted her friend, TikTok Bell, a legal manager at Penn, for advice on her plan to file divorce against her husband, Hope. Wendy complained to TikTok Bell that Hope has recently become aggressive and agitated after he was dismissed from his job. He ranted and raved every day without fail and blamed Wendy for losing his job. He claims he spent so much time providing Wendy expensive lifestyle and that he pays gap regards to his word, which linked to his dismissal. TikTok Bell advised Wendy to leave Hope. Wendy called Hope in TikTok Bell presence and informed him that she was filing for divorce. Hope got into rage and says to her, "You can never leave me. I will find you and drag you back wherever you are." The following morning, Wendy informed TikTok Bell that Hope had assaulted her and she had been admitted to the hospital. On TikTok Bell advice, Wendy lodged a police report against Hope. Inspector Penn interviewed Crystal, Wendy's neighbor, who gave statement to Inspector Penn that she saw Hope forcefully holding Wendy's left hand, and in the process of trying to escape, Wendy tripled and fell down the steps. Hope was charged with domestic violence at the magistrate court. At the trial in the magistrate court, Dr. John gave evidence that he was attending medical officer on the day of the incident and examined Wendy. He found wounds and scars on Wendy's body and they were associated with Wendy's version of events. Dr. John has since passed away. Hope was convicted and sentenced at the magistrate court. Hope has appealed against magistrate decision and obtained the stay of execution pending his appeal. Okay. Wendy has since unable to locate Crystal. Okay, now we have two persons disappear already lah. Then apparently it's an exception to hearsay lah. So the first people cannot be found is Dr. John passed away and number 2 is Crystal the neighbor. Okay. So number 1, whether TikTok Bell can be called to give evidence in the divorce proceeding. So basically, who is our TikTok Bell? TikTok Bell is the legal manager. So please don't write this legal manager as a legal advisor. There is a difference between lawyer, legal advisor, and also legal manager. I mean, legal manager technically cannot be considered as a lawyer lah. Okay, some more he's a bank legal manager. He's not your legal advisor. Okay, must make the difference. Because I think some student may see, legal manager, so is protected by privilege, so you cannot call him as a witness. So this is wrong. Okay, pursuant to Okay, this is 5 marks, so we can just make it simple. Lor. If it's a 10 marks or 7 marks, then maybe you can explain section 118, because section 118 basically is telling you everybody is competent to give evidence and can be testified in court. Okay, generally, yeah. But then, if those people are under the category of privilege, then you cannot force those people to give evidence in court. So back to these questions, since the Bell is not a lawyer, so 127 is not applicable. It's not a legal advisor. Then 129 also not applicable. So just make it short for 5 marks questions. Okay. Then number 2, whether Inspector Pam can be compelled to give evidence on Crystal's statement made to him in the divorce proceeding. Okay. So Crystal is the neighbor, So basically the neighbor says something to the inspector, right? Like here, cross report, and the neighbor gives statement. So for those students who are familiar with the syllabus, then you will know lah. Giving statement to the police and the exception, the only exception mentioned about police basically is section 32 sub 1I and J. Okay. So let me also explain to you what is the difference between I and J. So if you look at the title I, right, it mentioned the word is course of investigation. So it's only for investigation, okay? But for J, it's discharge of duty by police or public officer. So when both sections read together, right, I think you guys know, right, there's cases to dispute whether I and J should read together or should read differently, disjunctively or conjunctively. So what is the effect? Read conjunctively and disjunctively. If you read conjunctively means it must be an investigation conducted by a police or public officer. Okay? So in other words, if read disjunctively, as long as it's investigation, even a private investigator do an investigation can also use this exception under section 32 sub 1I. Okay? So I think there's a one past year question. I think if I'm not mistaken, just 1 year only. They ask if I have a private investigator do some investigation, but he's not come to court, can his evidence still admissible or not? That one, then you can use I, if I and J read disjunctively. But if you follow the cases say read conjunctively, then this investigation must be conducted by the police. Then only you can use hearsay exceptions. So back to this question. Since our Inspector Pam is a police officer, it's a public officer, right? So I guess it shouldn't be a problem. We use the exception under I or J. So 5 marks also, just easily say we can use I and J, either one, then settle it. Okay, C. Whether Dr. John evidence at the magistrate court can be admitted into evidence in the divorce proceeding. Okay, so who is Dr. John? Dr. John is the medical officer who conducted to say he found the wounds and also the scar on Wendy's body. Okay, however, he passed away, right? So this one is another exception to hearsay. So what is the exception here we can apply? Again, whenever the maker is not available, I think the first exception you can think of is section 32. So here, person passed away, I think you can use either 32 sub 1A, dying declaration, okay, or ordinary course of business. Why? Because this doctor also doing his job. His job is as a doctor, then he go and examine the patient. Okay, but because it's only word 10 marks. So which means you write both and then raise and dismiss. Why I say raise and dismiss? So let's say we go through 32 sub 1A. Number 1 is the maker must be dead, so Dr. John passed away, satisfied. Number 2, the clause of maker that come into question. Okay, here is a problem. Dr. John passed away is not because of this case, right? It's not because of the divorce, right? It's not because of the domestic violence, right? So then you cannot say, yeah, he passed away, then I can use this. So because they cannot satisfy the second requirement, Dr. John, that does not come into the question. So therefore, raise and dismiss. You can raise section 32 sub 1A, and then you say you cannot satisfy the requirement, therefore we cannot use it. Okay? Then we use 32 sub 1B. I think this one we can satisfy because, number 1, in the ordinary course of business, Dr. John is the medical officer on the day. So which means he is doing his job, so we can satisfy this first requirement. And number 2 is a statement which is based on personal knowledge of the maker. So the Dr. John has the knowledge, right? Because here say he found the scar on the body associated with the Wendy version of event. So all this shows that Dr. John has knowledge, and he also written a medical report. So he know what he's doing, he know what happened. Okay. So I would think this one, for 10 marks, you write section 32 sub 1A, But then dismiss it, say because the requirement cannot satisfy, then you write section 32 sub 1B. Okay? Then D, whether Wendy can refer to the magistrate court conviction and sentencing in the divorce proceeding. I think this one can, but again, it's only 5 marks. For those cases, when they mention I want to use other court proceeding or other court evidence, I think the section you can think of will be section 33 of subsequent proceeding. Okay, so I go through one time the requirement with you. So the precondition is that evidence given by a witness in a judicial proceeding. So yes, the criminal cases, the evidence is given by the husband, right? Because the husband committed a domestic violence. And number 2, unavailability. So the husband either dead already, or husband is incapable of giving evidence, or the husband is kept out of the way by the adverse party, or the witness present cannot be obtained without the amounts of delay and expenses. So this one maybe Wendy need to justify why you want to use the criminal court evidence. Is it because the husband not available to come? Is it because the husband in the jail or not? But on the facts, I don't think so because they mentioned what? The husband got the stay of decisions already. So which means the husband actually is available to come to court. Okay? And then following must be satisfied. Number 1, the proceeding is between the same party. So this one I think can be satisfied because the domestic violence is the same party, right? It's the husband hit the wife, and the divorce proceeding also between the husband and wife. And number 2, the adverse party in the first proceeding had the right and opportunity to cross-examine. So it means he can ask question on the other party. So let's say the wife got the chance to ask the husband question in the court. The husband also got the chance to cross-examine the wife in the court. Okay. And third one, the question in issue was substantially same as the first and the second. So I think this one also can be satisfied because whether you hit me or not, so that I want to have a divorce. So it's the same issue. Okay. So I think can be satisfied, except Wendy maybe need to prove why you want this subsequent proceeding to be used instead of calling the husband come to court again. Okay. Wait, I admit some student. Okay. So for 5 marks, just quickly use section 33. Can we use section 43? Okay, let me see what is 43. Judgment obtained other than those in section 40. I think can also, by reading it, it seems to me okay because it's a judgment. But I never applied this section before. But from reading it, it seems to me okay. Yeah. Thanks to our Cindy. Okay. Then, okay, I think you could make a good point. Let me write down. So next time I know. Okay, then we go to question 3. Okay, Serena executed an agreement with Moon for the sale and purchase Serena condo in the presence of Sun, Moon solicitor. Sun effect the transfer and registration of property to Moon, who subsequently transfer the condo to Settle, Moon wife. When Serena refused to vacate the condo, Moon commenced legal action against Serena for vacant possession of the condo. In her defense, Serena claims that the agreement was a sham and an illegal money lending transaction where Moon has previously lent her 500,000 and she was compelled to repay Moon 1 million. Serena alleged that when she was not able to repay the balance sum of 300,000, Moon compelled her to sign the agreement. Okay, with the okay. Serena intends to call Moon wife, Settle, as her witness and adduce in court a letter signed by Settle before the agreement, reminding Serena that she owed Moon the balance sum of 300,000. Serena also intends to adduce evidence of 2 similar transactions carried out by Moon with her sister, March, previously in which March has transferred her property to Moon when March could not repay her previous loan with Moon. Moon, in reply, denies Serena's allegation of illegal money lending transaction and claims that Serena had, in the presence of Sun, voluntarily executed the agreement, the transfer form, and other relevant documents to effect the sale and purchase of the condo to Moon. Further, Moon claims that Serena had applied to her bank for redemption statement to redeem the condo from the bank, for which the redemption sum was paid by Moon. that form part of the purchase price. Okay. So we need to advise our number one, whether Serena can rely on subtle letter to override the terms of the agreement. Okay. To be honest, when I first read these questions, right, I thought the answer is privilege between the husband and wife. But then when I read C, only I realized this is the privilege answer. So please bear in mind, whenever you answer the question, try to read up all the question first. Don't faster go and answer. And actually, the answer they wanted is actually is another part. So for this one, when I read again, I can guess I think the answer should be, because now they say override. So the keyword for me to find out the answer is override. So we have the agreement. We also have subtle letter. So agreement says it's a transfer or SMP, but the letter says you owe me money. So now, right now, which one we need to follow? Okay. So the suitable section I can think of is section 91. Why? Because here 91 says when terms of contract and grant of any disposition of property have been reduced by or by consent of the party to form of a document, and in all cases in which any matter required by law to reduce to the form of the document, no evidence, so it says no evidence shall be given in proof of the terms of the contract, grant, or other disposition of property, or for of the matter except the document itself, or secondary evidence is contains in the cases where which the secondary evidence is admissible under provision here contained. So what does it mean? So although every time when we talk about section 91 and 92, we thought it's oral evidence, actually they are not as simple only mention oral evidence. They are more like talking when you have one evidence ready, you cannot use another evidence to contradict with your first evidence. So for example, I have a written agreement to say I want to sell you my car. So you cannot later on you say actually you got another documents to override that agreement. So it becomes we don't know which agreement we should go and trust, So we should trust the first one or the second one. So back to this question, also the same. Right now, when Moon sue you for the enforcement of the agreement, asks you to deliver the house to him, but then now you say, oh, actually, this agreement is a shame. It's an illegal money lending agreement. The real one actually is like your wife letter to say, I owe you money. So you're basically saying you are using the second one to override the first one. Okay. So based on this section and also based on case law, you cannot use that one to override it unless you can prove the first one is affected by reshaping factor. For example, duress or undue influence fraud misrepresentation Okay, so I think to answer this 10 marks, I will write is that generally under section 91, you cannot use second evidence to override the number one. But unless you can prove the four things fraud misread duress undue influence and the burdens of you. This is what I can think of I to write out. Because I try to search some cases, right? I cannot find the similar cases. So I think it's based on how you can argue on it. Okay? Okay. Or you guys got better idea, please share and let me know. Okay, so number two, whether Moon can object to Serena introduction of two previous transactions with March. Okay, this one I think is quite obvious. It's similar facts evidence. So basically, they are saying that this is not the first time you are doing it. It's the third time you are doing it already because you've got two previous transactions. So for knowledge, please remember, technically, strictly speaking, Malaysia don't have similar facts evidence. Okay. Then how we admit similar facts evidence so basically we are using common law, section 11B, 14 and 15 So I will just quickly go through with you what is the difference because here is 10 marks so I believe you must raise and dismiss So 14 and 15. 14 and 15 is more like talking about menstrual intention, knowledge, how to say so. So for example, section 40, let's say do you guys know if you want to go and pick up some customer in airport, right? You require some license. But then I think it's a real cases there is a people who gonna catch by the police. But then when the police ask him, are you with license or not to pick up customer in airport? Then that person say, I don't know, we need license. Okay, so first time maybe the police let him go. Then the second time the police catch him again. Then he said, hey, I do know I need license. So in that case, when go to court, basically the public prosecutor can say, If the first time you say you don't know, it's fine. But then you do so many times already, which you got similar conduct for so many times, when you still say you don't know, right? Which means you admitted the conduct, actus real. You say, yes, I did it, but I don't know it's illegal. So 14 can use to prove based on your previous conduct, I can rebut your excuses to say you don't know. Actually, you know. Why? Because you did it so many times already. So section 40 is using in the situation where this real is admitted, but you deny mens rea. But then we can use section 40 to deny your mens rea to say you don't know because you've been doing this so many times already. Okay. And then 15 is also kind of similar, but then it's for accident. So one of the famous case I think is called Sunny Ang. Okay. So what happened in this Sunny Ang? Every time he got a girlfriend, he will bring the girlfriend go to swimming. So every time go to swimming there, the girlfriend will accidentally die one. Then every time also he bought the insurance for his girlfriend. So every time when they ask him, he will say, "Oh, I don't know, my girlfriend cannot swim." So it becomes a problem already, which means you admitted that it's an actor's role. You bring your girlfriend to swimming. But the main issue is that you thought it's an accident. You thought your girlfriend can swim. So when that happened, then also we can use section 15 to deny he meant to say you actually know you do it on purpose one. It's not an accident. Okay, so 14 and 15 is kind of similar, but one is for knowledge, intention, but 15 is more like for an accident. So whenever the question talk about accident, then you can use it to deny the menstrual. So back to defects, did Moon admitted to say, oh, I know this is an agreement. I know this is a money lender agreement. However, I don't know what. No. Because Moon straight away denied the entire thing. Moon say no such thing. So in that case, when he denied everything, you cannot use section 14 and 15 already. Understand? Okay. If you guys don't understand, you ask me. Okay. And another one is section 11. The reason why I explain 14 and 15 first is because 14 and 15 is you can raise and dismiss, but at least whenever they don't mention about menstrual, you can raise and dismiss. But section 11B is more like very general one. They just say, are you highly probable? Is there a chances you got more probability you do this? So for example, I like to driving very fast. So is it because I like to drive very fast, so I got higher chances to have conduct illegal racing in public places? So 11 basically is like, is there more higher chances you do that? So on the facts, just because I have two previous with my sister, is there a higher chances I will do the third time? So this is like arguable. So section 11 is like that. And common law even is whiter than other sections. Why? Because the test is whether the evidence of such high degree of relevance that the probative value outweigh the prejudice effect. So which means is such evidence so important, so useful until I can disregard the prejudice effect. So which means even this evidence may have some unfair effect, is fine. We can ignore it because the evidence is so important, so useful. So on the facts also, again, I don't think so. Why? Because just because he previously got do these two things with the sister, right? There is no connection with this case. Unless you can prove some connection with this case, or let's say he got the bank account always lending money to people, or let's say he's alone and everybody know that, then maybe you still can use it But just because previously he got some dealing with the sister, nothing to do with this case, strictly speaking. So I think it's a bit hard So for this question, I think you can also try raise and dismiss To be honest, I think most of the time, right, the past year question when they ask about similar facts evidence, I think they didn't ask it so nicely I only see one time they ask the similar facts evidence very nicely is where they give a dialogue like TPP ask the accused questions, then ask him, have you done this before or not? Let me show you. I go and search which ask the questions. I think it's this one. So this is 2018 November evidence paper. So in the dialogue, the DPP say, previously you were charged with the drug possession. So accused say yes. So then DPP say, in that previous action, the drug were found to be packed in the plastic bag tied with two rubber bands and hidden under the driver's seat of the car driven by you. Then accuser also say, yes, but the car did not belong to me. Then TPP say, but you were found guilty of the charge in that case. Then accused say, yes, but the case is still pending appeal. Then TPP again say, in this case, you are charged with possession of same type of the drug in the previous action, and also on this occasion to the drug were packaged in the plastic bag tied with two rubber bands and hindered other driver's seat of the car driven by you. Yes, but the car did not belong to you. So you see, they keep on asking you, the TPP lah, they are trying to show last time you do this in the same way of matter, this time also you're doing it in the same way of matter. So this one, I think, is the nicest similar facts evidence they ever asked in the past question. Why I say nice? You see, we use section 14 and 15. If today the TPP say, previously you done this with this kind of matter, yes or no? If the accused says, yes, but I didn't know there is a drug, okay, then you can use 14 and 15 to rebut, because previously you say you don't know. Now also you say you don't know. Isn't it weird? Every time also you use the same method, but you don't know it's a drug. Then you can use 14 and 15 to prove you actually know. You do a similar thing. But in this question, you cannot use 14 and 15 is because he said, the car did not belong to me, which means he didn't say, I had no knowledge, it's an accident, or he never denied the menstrual. He straight away denied adversarial plus menstrual, because he said the car is not belong to me. Here they say the car is driven by you. So it's not my car. So I deny the adversarial already. So it's not my car. I don't have the intention to keep the drug. So I deny, basically I deny everything. Okay. So this question is 25 marks. You can write 14 and 15. Then you try to explain why cannot use 14, why cannot use 15, and why we can use section 11B. I think section 11B still arguable lah. Why? 2 times same matter same car is there higher chances that you have the experience doing it? So that's why it's the same kind of matter you package the drug. Okay, so this will be the best similar facts evidence in the past question I ever seen. So back to this one, I think it's not so nice. They are asking not so clear. Okay. Then third one, whether Serena can compel Sato to give evidence at trial. So this is the one I mentioned. You cannot force the wife to give evidence in court because it's protected by the privilege. The section I think is 122. Okay, are you guys understand for this? So basically, section 118 can evidence act to say, as long as the person understand the question, can give rational answer, then the person is competent and compellable to give evidence. However, certain type of people, you cannot force them to give evidence. Number one is judge in court law. So you cannot say, I'm losing the case in court number one, so now I'm appealing, I want to force the judge to give evidence in court. No, and second one is the husband and wife law. You cannot force the husband and wife go and tell what you guys discussed at night. Cannot. And the third one is about our country security lah. Okay. And the fourth one is our lawyer law, lawyer and client. You cannot force the lawyer to tell what your client told you law, and then others lah. Okay. So for this question, 5 marks I think can easy count in settle. You cannot force a wife to give evidence in court unless, as sections the person agree, consent, which means the husband or the wife say, okay, I can tell. Number 2, in the suit between the married person. So let's say husband sue wife or wife sue husband, then of course they can tell. Number 3 is the married person is prosecuted for a crime. So for criminal also, you can be forced to tell. Okay. So this for our C. Can I proceed to number 4? Okay. Mati, I think it's called Mati was charged under section 302 of the Penal Code for the alleged murder of victim on the night of 7 October 2023. PP, as a TPP, summoned multiple witnesses to provide testimony in support of the prosecution case. So PP posed the following question to IC PW1. Okay, PW1 is prosecution witness number 1. Okay, who happened to be victim's sister. Number 1. Were you present at the corner of the street where the incident occurred that night? During your presence there, did you have any clear and unobstructed view of the incident? So, Mati Kauser, Manson objected to both questions. Okay, maybe I can explain one by one. You see, these questions are when the TPP asks the witness, are you there? When you were there, can you see clearly or not? These kind of questions are we call leading questions. I don't know if I explained before or not. Every witness will have three stages. Number one is called examination in chief. Number two is called cross-examination. And number three is called re-examination. So what is the difference? Number one is if I'm calling my own witness, I will ask my witness some question. That one is called examination in chief. My own witness, I ask my witness questions. And number two, my opponent party will ask my witness question. It's called cross-examination because they want to ask him. So for example, my witness say, yes, I saw so and so kill my sister. Then the opponent party will challenge you to say, are you sure you see? How you see? Where you see? Are you wear your spec or not? So they will challenge the witness. This is called cross-examination. So when the opponent party asks the question already, he sit down, then me as the lawyer for my witness, I will ask question again. It's called re-examination. Okay? So in this case, you see, PP as a TPP, ask his own witness, PW1, he asked all these two questions, is a leading questions. So actually pursuant to what we call the evidence that examination in chief and re-examination, you cannot ask leading question one. Okay, I show you the sections. Okay, 142. Leading question may not, if objected by the adverse party, be asked in an examination in chief and re-examination, except with the permission of the court. So basically, in examination in chief, which is I ask my witness, or re-examination also I ask my witness, I cannot ask leading question. What is leading question? Leading question is like I leading you to answer the question what I want. The most obvious example will be I ask you to answer yes or no lah. So you see this question, were you present at the corner? So the witness can only say what? Yes. During your presence there, did you have a clear or unobstructed view of the incident? So the witness can only say yes, right? So in order not to ask the leading questions, the proper way should be, can you explain to the court what did you see that night? And let the witness go and tell the court herself. Let's say the witness will say, oh, on when I was walking on the street and then I saw something happen. Let the witness go and tell what happened. Instead of you straight away telling the story already, so the witness only forced to answer yes or no. This kind of leading question can only be asked by the opponent party in cross-examination. So understand, these two questions actually is wrong. So the objection actually is valid pursuant to section 142. Okay? Okay. During PP examination of Inspector Casey Koh, so you see, prosecution witness number 2, halfway through the testimony, Inspector Koh asserted that he could not recall the specific of the incident due to its occurrence several months ago and the workload involving number of cases. Consequently, he expressed the need to consult a notebook and accurate details. So mentioned objected to Inspector Koh referring to the sort of notes. So again, he's objecting to say, you cannot look at the file. You must remember based on your memory. So this one actually also got cases. And let me see. This one. So the case is Mohamed bin Seman. So in this case, the court say 3 conditions to be satisfied for refreshing memory while under examination. Number 1, the written by which memory of the party is to be refreshed must have been made by the witness himself. So must be he written it. So on the facts, he say he want to refer to the notebook. If prepared by himself, then it's fine. Okay, first condition. Number 2, the second condition, the written made at the time of the transaction concerning which he is questioned or soon afterward, the court consider it is likely that the transaction was at the time refresh his memory. So what does it mean? It means when you make these notes, must be made at the time of the transaction, not before. If you, let's say today you say, I'm so happy, later what will happen? This thing cannot be used because it haven't happened. It must be made at the time it happened. Even after slightly a bit also can, soon after. So on the facts, I also guessing lah, it record after it lah. How can the police pre-record something haven't happened, right? And number three, witness cannot refresh the memory by right, which means you cannot automatically to say I entitled to refresh. You must ask the court first, and the court say yes, then only you can refresh. So for this objection, I would say it depends on the court law. So you need to mention the case, this case, Mumi bin Seman, and also the section 159, 160, 161. Okay, and we continue. Before the prosecution closed its case, PP applied to recall IC as she claims that due to an oversight, she had missed out on asking IC some important question. So mentioned also objected to recalling IC. So what does it mean is recalling? Recalling basically is like this. You know, there's a difference between plaintiff case, defendant case, prosecution case, accused case, right? So it means when prosecution finish asking on his witness already, it will close case. It's a prima facie case. So the prosecution will not call any witness anymore. The defendant will call their witness. Okay. So recalling means prosecution already asked all the witness question already. So close already. By right should proceed to ask the defendant witness question already. But now suddenly before starting this one, prosecution say, hey, actually I forgot to ask one question. I want to ask the witness again. So it called recalling witness. So this kind of situation in evidence, I think it asked a few times already. Actually, that case, based on my understanding, is in civil case. Just a moment. So for this kind of cases, the cases you can use is this. Tang Kiet Kiang, if I pronounce correctly. Okay. Reopening the case is more likely after plaintiff has closed their case and less likely after defendant closed their case. What does it mean? So like I say, there is the two stages, prosecution case, then only accused case. So if let's say you close the prosecution case, then you want to recall, it's still okay because the defendant, the accused haven't started their case. But now if let's say you close your case, defendant or accused also close their case already, it's end of it already, it's going to deliver decisions already. You want to call your witness again, then that one is less likely. But if you just close your case only, you want to call your witness, still okay because the defendant or the accused haven't started the case yet. So pursuant to this case, it depends on what stage. Okay. So back to here, I think we haven't started the accused or defendant case yet. So maybe we can still have the chance to call IC again. Okay. So then Manson also argued that the court should view IC evidence with circumspect as she is a sister of victim and therefore she will have vested interest and will overzealous in with wanting a conviction. So basically they are saying that you are the sister, so maybe you will be biased. You will give some evidence just to secure the conviction. Okay. So objection to PP question to IC. So this one we discussed already, which is a leading question. 142 say you cannot have leading question. Then number two, objection to inspector call request to refer. This one is the case I refer. Mami bin Semat. You need to satisfy three requirements. So at the end, you must see whether the court allow or not. And then mention objection to PP recall IC. This is the case I shared just now. Tang Kak Kiet, if I pronounce correctly. It depends on the stage of the case. If still early, then you can call. If later case already, close the defendant case already, then less likely. Okay. And last one is the argument on IC relation with victim. Okay, this one actually I got found a case. And let me show you. So basically, I found a case to say just because the witness is related to the victim, it doesn't mean he or she is an interested witness. It doesn't mean you cannot trust them just because they got some related blood, biological or blood related. It's nothing to do with whether he can give evidence or not. Okay, maybe you guys can take note of it. I can cut to the group also lah. So related is not equivalent to interested. The term interested postulated that the person concerned has some direct interest in the result of the litigation, such as interest in the degree of a civil case or seeing that the accused is punished. So basically, you just want to take revenge lah. You want something happen, so you will say something in your favor lah. But just because I'm related, it doesn't mean I will be biased lah. So basically, the case is saying like that lah. So I will copy this, then you guys can have it. But this is Indian case lah. I cannot find any Malaysia case lah. So I will share. Good. Let me see if I can share. Yeah, okay. So I share in the group already. So let us back to our questions. Okay, so for 6 marks, I think you write that one. It's fine lah. Okay, then we go to question 5. Okay, K is in the business of supplying palm oil fruit crushing machine. So bracket called machine. C purchased the machine from K for 100,000 for use at the palm oil mill. K issue a quotation, delivery order, and invoice for the purchase, all of which as acknowledged received through Adu. As Bangladesh employee, each document contained the same terms, including that the machine was delivered and received in good order and condition with a warranty of 3 months from the date of delivery, and the machine shall not be used until K has tested and commissioned it. Okay, so S pay 90,000 and the balance is to be paid after K has tested and commissioned the machine. Immediately after the delivery of the machine, the government imposed MCO arising from the COVID pandemic. Soon after the lifting the MCO, S attempted to use the machine, but it did not function and informed K accordingly. K appeared at S factory and it was discovered that the machine was not operational because several parts has been burnt out. K informed S that S had to pay the new part to replace the burnt out part. K explained that S had used the machine before K could test and commission it, and that warranty period was over. Yeah, so far understand? So basically, they buy the machine and then they say, you cannot use it until I test it. But then due to MCO, now K feels has been used before I test. So S demanded a refund of 90,000 and commenced legal action against K, claiming the machine was not unmerchantable quality. K engaged M, a fresh mechanical and electrical engineering graduate, to investigate the problem with the machine. In his report, M explained that the part of the machine had been burnt out were the second-hand part, which were not suitable for the machine. He further explained that due to the poor quality of this second-hand part, the machine could not function. K sent P to discuss with S how to resolve the dispute. However, S was not at the palm oil mill and instead, P met Adu. Adu informed P that he had removed the original part from the machine and sold them as he needed money for his alighting wife. Adu then replaced them with a second-hand part which he bought from Testa. Adu has since fled the country. K has a copy of the quotation, the reorder and invoice, and the original were extended to Adu. Okay, slightly long the facts, but basically there's a few witnesses involved. So, admissibility of the copy of quotation, the reorder, and invoice. So you see, whenever they say copy, then you know means there is no original with him So let's have a discussion on the admissibility of the best evidence So you guys know, right? Section 64, 65, if I remember correctly, we need the best evidence, which is we need the original. But then we also have the section to say in what situation we can use photocopy or secondary evidence, right? So, okay, so 64 say we must use best evidence, right? But 65 allow us to use secondary. So the question is, where is the original? So I suppose the original is with S because the quotation and DO original has been extended to Adu. So they don't have it. So the S section we can use is section 65 sub 1A, which is when the original is shown appear to be in the possession of other person, which is Adu. But now Adu disappeared already. So we can use this. However, before you want to use 65 sub 1A, you must serve a notice to produce under section 66 on ADU or X first, which is to tell them, look, now I need this original, and original is with you. Please produce in court. If they refuse to do so, then only you can use this 65 sub 1A. Understand? Okay. Number two, the admissibility of M evidence in his report. So who is M? M is the first graduate to conduct the investigation lah. So basically, he found out that the machine was using second-hand part lah. So whether his evidence can be used or not. Okay. At first, of course, I would think of is the opinion evidence lah. But then, one thing I want to highlight to you guys is that opinion evidence in order to use opinion evidence we have two requirements need to satisfy. Number one is area or expert. Number two is qualification. So on the facts, of course, I don't think everybody can check the machine. Only certain people with certain knowledge can check. So the first requirement, definitely we can satisfy. But the problem is number two, qualification. So the facts he mentioned, M basically is a first fresh graduate. So maybe he may not have the sufficient qualification to check. So this is the problem. Okay. But then don't worry. If you guys know Kui Chan this case, so basically in Kui Chan, the court differentiate between facts and opinion. What does it mean? Facts is something everybody see who give the same conclusion. For example, 1 plus 1 equal to 2. This is not opinion. This is facts because everybody will give the same answer. Opinion is more like A will say different opinion, B will say different opinion because everybody may have different opinion. Then that one is opinion. So based on this, the machine was used second-hand part. I would think this is not an opinion because even later on also supported by ADU. ADU also admitted, actually, yes, I need money, so that's why I take up the original part, I replace with the second-hand part. So I would say this is a fact. So if you use Kui Chan, then at first I think for 8 months, you would raise and dismiss section 43 of the, what we call, section 45 of the opinion evidence first. Then you say he's the first graduate, so he may not able to satisfy the qualification requirement. However, if we follow Kui Chan, if you are just giving facts, you are not giving opinion, then you don't need to satisfy section 45. So like that, then the M evidence can be admitted in court. Okay. So C, whether P can give evidence of what Adu told him. So again, what Adu told him is that Adu informed P that he had removed the original part from machine and sold them as he need the money. So this one, by right, when Adu say that Adu must come to court, but since Adu has disappeared already, then we need the S sections, because now P is a second person to know it. So what we call S section to hearsay. So here, I would say the best one will be section 32 sub 1B or 73A or I think these two we can only use section 32 sub 1B. I think the suitable one is section 32 sub 1B because it's an ordinary course of business. P is doing his job. I go to the place because my boss sent me there. C was not at the palm oil. No, here. K sent P to discuss with S to resolve the dispute. So basically, P is doing his job. So I think you can use section 32 sub 1B to say that although Adu is not there, but because P is doing his job and P also has the personal knowledge on it, so he can use this exception. So, okay, 5 marks. Make it easy. So D, whether K can call T, who has a speed impairment, to give evidence in trial. So basically, they are saying that T is OKU. So whether an OKU can get evidence in court or not. So this one will back to what I say just now, section 118. This one. All persons are competent to testify unless the court consider they are prevented from understanding the question put to him, or they are prevented from giving rational answer. So based on this, just because you have speech impairment, it doesn't mean you cannot give evidence. You can still use body language or you may write down answer. So I think it's fine lah. So you just use section 118. You say everybody can understand, can give rational answer. It should be able to give evidence. Okay, 5 marks. Make it simple. Then we proceed. Orun was charged with murder of his girlfriend, Chinu, which took place on the night of 15 February 2024. Ibella, who lived across the scene of the murder, were called to give evidence at the trial. 119. Okay. Cindy say 119. Let us see what is 119. 119. Dumb evidence. Dumb witness. I'm not sure if we can use this because my understanding of dumb means like you have some impairment on intelligence. But here they just say speech. I don't know it's the same thing or not here because they're using it as speech impairment. But I guess you can use it, but I would think it's not the best and suitable one. Not the best one. You can mention it. Real dumb for me is like you may have some you don't really understand. This is my feeling, but I'm not really sure. Okay. Okay. So this one, TPP asked, did you know Chinu? Then Abella said, yes, she was like my neighbor, lived across from me. Then TPP asked, explain what you heard and saw on the night of 15 February 2024. Now you see, this one is not a leading question because they are giving chance for the witness to answer. So this one is still fine. So then Abella said, I saw the accused drive up to Chinu driveway. He was in his army uniform with a revolver at his side. A little moment later, I heard the deceased voice saying, please do not shoot me, I forgive you. And then I heard a loud bang and sounds like a shotgun. Okay, so Orun counsel objected and submitted that Abella evidence is hearsay and inadmissible. Okay, this one basically they are saying that she said she heard so you never see it so you cannot use it It's a hearsay you hear only you never see it with your eyes So I think for this one we can use the best one I think is res judicata. Anyone understand what is res judicata or you guys don't understand? Sorry, it's not res judicata. It's re geste. Sorry. Re geste. Re geste. This one, common law re geste. So, common law re geste provides for an admissibility of simultaneous exclamation where the possibility of conjunction and distortion can be disregarded. So, in layman terms, my understanding is that the thing happens so sudden, so dramatic until you cannot lie. So, for example, you just heard a shotgun. You won't go and think about like one little thing you say, oh, maybe it's like celebrating Chinese New Year. You may not go and think of other thing. So the evidence you are giving is like so real because the incident is still dominating your mind. You no time go and think about other things already. It's a real thing. What you feel is a real feeling that time. Okay. So Crown versus Andrew explain in order to admit a statement under res geste, 4 factors need to be considered. Okay. Number one, whether there's a possibility of conjunction and distortion. Conjunction and distortion means like do you have the chance to make a fake evidence or not? It's not a real evidence. You may tipu, you may cheat. Okay. Number two, whether the event is so unusual, startling, and dramatic as to dominate the thought of the person, the maker. So usually the thing is like so dramatic until you cannot lie. Okay. Number three, the mind of the maker is still dominated by the event. So your mind is still thinking about the incident. Got no time to go and make the fake story. And number four, whether there's a possibility of error in the facts narrated in the statement. So again, also saying you had no way go and tipu one. It's so real. It happened so fast until you cannot go and make a fake story. Okay? But basically, this is my understanding. So from here also, I couldn't go and think of when I heard all these things, right? Then I go and make a fake story. And why should I make this thing? Okay? I think I can share some UK example to you. So I think there's one case, but I forgot the name already. So basically, it's the husband killed the wife. So when they arrest the husband, then the husband say, I wasn't present in the scene. So, however, when I think the doctor actually making a phone call, so the doctor actually say, hello, baby. So later on, I think the doctor or the wife died, I forgot already. Then they use the evidence to show that actually you were present there. Otherwise, then why your doctor say, hello, baby? Your daughter couldn't go and lie, ma. Why your daughter want to say something is not true, right? So then they use that evidence to say when this thing happened, there is no way the doctor will lie. It can be proved that actually you are present there. But now you say you wasn't present there, so basically you are not telling the truth, lah. So back to this one also the same. There is no way for this our Albella to make a fake story, ma. When you heard it, then you just say it, ma. So I will use it as a exception to it, lah. The register as an exception to admit the evidence, although Abella didn't see the thing happen, lah. Okay. And let me see anything else we can use. No, I think the most suitable one is that one. Or else maybe you can use relevant evidence. So again, the section 6, same transaction, is kind of similar to reg estate 1. Last time they even used section 6 to admit the reg estate common law. Because actually, reg estate is a common law. It's not in our evidence act. But sometimes, in order for them to use reg estate, then they will use section 6. So I think you can write section 6 as well. Same transaction. The thing happened on one same timeline. Okay? But this kind of question, I don't encourage you to do because it's 15 marks. I think it's not easy to get. Okay? Then shall we go to next one? J-Law was charged under Section 179B of the Capital Market of Service Act 2007 for misleading an investor for false representation of an investment scheme involving purchase of the security. At the trial, the DPP intends to adduce evidence of document extracted from J-Law computer. They were obtained from J-Law confessions. The presenting judge had early rules that J-Law confession was inadmissible. Okay, I will explain later. So advise the DPP by reference to the Evidence Act and relevant case law on the admissibility of document extracted from J-Law. Okay, here actually at first when I read the question, I don't understand what they want. But I think whenever they talk about computer confessions, so the first thing you must remember is Section 90A. So basically, Section 90A is document produced by a computer, and then also in the course of ordinary use, if I remember. Oh, sorry. Okay. So, produced by computer. Number 2, in the course of ordinary use. Okay. But please remember, whenever we talk about Section 90A, we also talk about the statement made by the accused himself. Always remember sub 7. Because, let me go through one time with you. Notwithstanding anything contained in these sections, a computer produced by a computer, a document produced by a computer, or a statement contained in such document shall not be admissible in evidence in any criminal proceeding where it is given by evidence, be given in evidence by or on behalf of the person who is charged with an offense. So which means if the statement is given by the accused himself, is inadmissible in criminal cases. So on the facts, criminal cases, right? Charge, and number 2, the document confession is given by Jolo himself, right? The accused himself. So actually it's inadmissible. So the presiding judge say the confession is inadmissible, actually is right. So you basically just need to use Section 90A cap sub 7. This is inadmissible already. You cannot use his confessions. Okay? Remember these sections. Are we good? Are we good? I continue. Okay. Our last questions. Ben and Mark were at Club 54, a duplicate establishment, attempting to engage Mimi in a conversation. In an attempt to impress Mimi, Ben and Mark purchased a drink for her and had it delivered by a waiter. However, Mimi declined the drink, conveying her rejection to the waiter with the statement, I don't do loser. The increased Ben, leading him to confront Mimi and put the drink at face. Meanwhile, Mark verbally berated her exclaiming, "We may be loser, but you are just loose." Okay. Ben is charged with an assault, and Mark is charged with a criminal defamation. Ben claims that he did not intend to throw the drink at Mimi. Okay. So basically, it's like two guys fighting with a girl, then the girl say no to them. Okay. Okay. A. Ben give evidence that he is a church goer. Okay. I give a free tuition at the orphan near his house that he will never attack women. Is Ben evident admissible? Okay, so basically he's saying I'm a good person, I go to church very often, I will never hit women, something like that. Okay, so I would think this is what we call good character evidence. So because you are basically saying you are a good person, so it's a good character. So Section 53. In criminal proceeding, the fact that the person accused of is a good character is relevant. So which means for criminal, you can say you are a good person, that one is fine, it's okay. But then, please bear in mind, when you say you are a good person, then under section 54 sub 2 sub B, your opponent can attack your character, can establish your bad character. I think the logic is like this. If you never mention you are a good person, of course, character is not relevant in this case. But when you say you are a good person, right, in order for me to rebut the argument, so the law also allow me to say, adduce your bad character evidence. So this is fair. But this one, I think later the question will ask. But for this question, 5 marks only, then you just cite section 53 to say good character is relevant evidence in criminal proceeding. That's it. Okay. Then, assuming ban evidence in paragraph B is admissible, can DPP in cross-examination ask B about his womanizing way, Ben's womanizing way? So this is like I say, when you say you are good people, then under section 54 sub 2 sub E, the DPP actually is allowed to attack your character. So I just quickly go through with you. Firstly, bad character may be adduced where he has personally or by his advocate asked prosecution witness question with the view to establish his own good character or has given evidence of his good character. So when you are trying to establish a good people or you are attacking other people's character, the other side is allowed to attack your character already. Okay? So basically, when you are saying you go to church very often, you give tuition, then the PP is allowed to attack your character. This is first limb. Second limb is bad character may be adduced where the nature and conduct of the defense is such as to involve imputation on the character of the prosecutor or prosecution witness. So it basically you are attacking them, then people can attack you. It's the same thing, but it's firstly and second limb. Okay. For example, you say the witness fabricating evidence. So when you say people fabricating evidence, giving false evidence, then people can attack your character as well. Okay. So this is okay. This is 53. This is 54 sub 2 sub B. Okay. 5 marks. I think quite easy, right? I mean, if you guys don't understand, please let me know. Then C. Mark asserts that he was an innocent bystander, claiming he merely reacted to being labeled as loser. He maintained that the entire scheme to approach Mimi was solely Ben's idea. Can bank lawyer cross-examine Mark on his previous conviction for assault on his ex-girlfriend? So basically, like two accused. So they want to blame to each other lah. So when Mark said no, it's Ben's fault, not me. Can bank lawyer attack Mark or not? Okay. So refer to here, 54 sub 2 sub C, bad character may be adduced where he is given evidence against other person charged with the same offense. Okay, charged with the same offense. Although, yes, against other person charged is okay, but with the same offense, then cannot. Because on the facts, Ben is charged with assault, Mark is charged with criminal defamation. So therefore, you cannot attack. Back to this question, bank lawyer cannot cross-examine on Mark because section 52 sub 2 sub C only allow where it's a similar or it's the same offense. But on the facts, it's not the same offense, so cannot. Okay, 5 marks also easy lah. Just raise and dismiss. Okay, D. Mimi initiated a civil suit for damages against bank for assault and against Mark for defamation. So remember, just now above is criminal, here is civil. In civil proceeding, is Mimi lawyer permitted to cross-examine bank regarding his reputation for socializing with women and engaging in intimate behavior at his preferred pub? Wait, this is for reputation. Just a moment. Okay, so basically this is silver case. When Mimi sue bank for assault, he want to know whether he can cross-examine him about his character, bad character lah, in silver case. Okay, if I remember correctly, it cannot no. For silver case, generally the reputation of character is inadmissible, except 52 and 55. So what is 52? In civil case, the fact that the character of any person concerned is such that to redeem probable or improbable any conduct imputed to him is irrelevant, except as to his character appear from the facts is otherwise relevant. So what does it mean? So which means generally you cannot use people character evidence in civil proceeding unless it is otherwise relevant. How to say? Okay, let's say defamation. I think the suitable one I can say is defamation. So for example, generally we shouldn't talk about character, but then from defamation, we wanted to know this person's status. For example, you say Anhua or you say Reno, it's two different people, two different status. Our character also different. Our social status also different. So in that case, then character will be relevant because these cases is talking about character, how you behave. So from this here, you must take note, when they are suing bank for assault, but now you want to ask for reputation, then cannot because assault and also character got no connection. But on the other hand, meant for defamation, then it could be relevant because how I behave, how Mimi behave, is if Mimi is a flirting woman or not, is relevant about character, so that one will be relevant. But for assault, then cannot. So you must mention, no, generally is not allowed unless 52. For example, defamation, and 55. So what is 55? 55 is in civil cases, the fact that the character of any person is such to affect the amounts of damages it ought to be received is relevant. So for example, I think I can give the example is accident case. So when you hit people car and your conduct, how you, whether you will admit your fault or not, whether you're willing to cooperate or not, all these things will be assessed in the amounts of damages. If you cooperate, if you're willing to help them, you admit, you save everybody time, this kind of conduct will be relevant in assessing the damages, So please remember, I repeat, in civil cases, generally it's not relevant in character. But unless it's a defamation, but here they didn't say defamation for 52, but I can think of, and the example is defamation because we want to see how you behave usually and also your social status. And 55 is more like in assessing damages, then it be relevant. But in this case, because I assault you, if you say you want to see my record of hitting women, all that maybe is relevant because you want to see my behavior. But here you want to see whether I flirt with other women in other part or not. I think it's not relevant. It's not relevant under 52 or 55. Okay? Then last one. Mark lawyer summons the bartender Jim to provide testimony. Is Mark lawyer allowed to inquiry from Jim about an incident occurring a week before the current incident, during which Mimi reportedly became intoxicated and engaged in lap dancing with multiple men at the bar? I think this one will be relevant. Why? Because Mimi sue Mark is for defamation. What defamation? Because she, let's say Mark say she is a flirty woman. So whether Mimi dancing with other girl or not can prove whether I'm make a defamatory statement or not. If I can prove it, you really dance with a lot of men, right? You are flirting woman. So then this defamation case cannot be established. So this one can be relevant under 52. Why? Because your character is relevant. And also 55. Why? If let's say the court still find I make defamatory statement, but you do have the character always like flirting around with guys, then in assessing the damages, maybe the court will give lesser. So I think this one you can use 52 and 55 for mark cases because it's for defamation. But for this one is assault, I don't see the connection there. Okay? I don't know if you guys understand or not because 52 and 55 sometimes they don't say it very clearly. Okay? Any questions, guys? Are we good? Are we good? So if we are good, I will call it a day. Okay. Okay. Thank you, Ashley. Okay. So thanks for your time, guys. So enjoy your weekend. Okay. Oh, okay. Cindy say, I have a silver question. What is the difference between JIDA and JIDD? Are they often used in real life? Okay, JIDA means judgment in default of appearance, which means when Renault sue somebody, that somebody must file memorandum appearance to say that I will appear in court. But when she don't, the person fail to file it, then Renault can straight away get the judgment already. So that one is called JIDA. Okay, so in other words, JIDA is where the opponent party fail to file appearance. JIDD means judgment in default of defense. So same logic, when the other party fail to file defense, then I ask for the judgment call, judgment in default of defense, because you fail to file defense. In simple terms, fail to file appearance, judgment call, judgment in default of appearance. Fail to file defense, judgment in default of defense. Okay? Yes, JIDD means he already filed appearance, but he failed to file defense.
We should focus on the thing. No.
Do you feel this paper doable? I would say actually every year also not doable because they certainly have some questions we could not answer. But for this evidence, I think you want to do 4 questions, still can do. It's not until the level you cannot do 4 questions. So I think still doable.